Welcome to JustWannaQuilt, a research podcast coming out of Tulane University Law School, where we explore all kinds of things, stories about quilting, tools, field trips, maybe some famous quilters stop by, and, of course, a little bit of copyright thrown in just for fun. This is Elizabeth Townsend Guard. I'm a law professor at Tulane University Law School, and I just wanna quilt. So today we talked to Chris Reed. He's an entertainment lawyer in LA, works with major studios. He's been on our show before. He comes today to talk to us about copyright again, and we have a great conversation. I hope you like it, and we really talk about the practicalities. This is Chris Reed, who is amazing. He's a lawyer, rock star lawyer. He came to us before. You've heard him before. Ricardo Gonzalez is sitting in with me. You all know Ricardo. And I'm Elizabeth Townsend Guard, and we're talking about copyright issues. My question is, so we've had this scenario that's going around in the quilting world where someone posts an image, then an evil group, no, not evil, but some group takes that image and claims that they are making a quilt for $50. You can get a very fancy quilt, and it looks like it's going to be a digital copy of an image, but it turns out when you put your credit card information in, you're not even getting that. It's just a credit card scam. So, and I asked you, since you work in LA and are an entertainment lawyer, are you seeing this elsewhere, and how are we supposed to understand what's happening?
Yeah, so we actually see this a lot, and what it is are it's exactly what you say. They are, I will agree with you. They're evildoers that are using content as a way to hook people into their illegal scheme, and a lot of these are run offshore, where they're sort of outside the reach of U.S. law enforcement and U.S. courts. But what they do is exactly what you described. They offer something content-based that somebody wants, and that person puts in their credit card information, and they get the credit. The evil party gets the credit card information, and nothing. The content is never delivered. And we see this a lot, particularly with pre-release films, where people will. Our industry announces that films are coming out many months, sometimes years in advance. So you may see online some website that says we've got the latest, whatever movie that is not even in theaters yet. And it looks like it's, a way to get the content early, but in fact, it's just a way for them to get your credit card information. So, and the challenge with it, as I say, is they're kind of outside the realm of traditional law enforcement tools. So it's really, there are places you can report them, but it's very difficult to get any action just because they're hard to track down.
Right. So any advice to the quilters out there that are freaking out? You were so kind because you responded when I had somebody email already, but I'm curious what your thought is about what to do, I guess. Yeah,
so it's tricky. You can send takedown notices because presumably they're using, infringing material on the site itself. You can send a takedown notice if you can figure out who's hosting the website. But the problem there is that the websites are usually also hosted offshore or by companies that simply aren't compliant with the DMCA, either because they're criminal actors themselves or they're located outside of the United States and feel like they don't need to comply with the DMCA.
And they pop up and down, right? So like when you click on a link, it's gone. Sometimes they're using Etsy, sometimes they're using their own site. Like it's all over the place.
Exactly. Yeah. So that's something else they do. We call it domain hopping, where you might shut down one of them and then they pop up somewhere else on another domain that looks very similar to the one they had before. And I think we used this analogy last time we spoke, but it really is like whack-a-mole, which I always hesitate to use that analogy because, of course, whack-a-mole is a trademark. But it is the sort of thing that we see all the time. And it's just, in some way, I think one of the things I told that person in the email was, in some ways, it's a sign of success that your stuff's getting ripped off because this is what happens to the big content companies all the time.
We've made it. Is that what you're
exactly.
saying?
Yeah.
Yeah. That's interesting. We talk about that in class. That's really interesting. Okay, so that was the first question I had for you was, see it as a badge of honor that your stuff is getting ripped off. They're not actually copying your stuff. They're just making people think they can get versions of your stuff that's not true. Is there anything else that you can do proactively in terms of, because what you're saying is the people that are getting harmed are really, you're getting harmed because your brand is out there, but what's really happening are the people that unwittingly are paying money. If you think my thought was, look, these were for like $50 for a quilt, and that is not, you're not going to buy these kinds of quilts for $50. There's like no way. So my thought was like, if it's too good of a deal, like that's a sign that this is not legit. Is that like...
Yeah, I mean, and the other thing that we often get told a lot is to do a better job of search engine optimization, which is really frustrating because, we spend a lot of time trying to get search engines to take, unlawful listings out of the index, or at least demote them. And one of the ways you can do that is by making sure that the legitimate product shows up more readily in the search results. So, one thing that quilters, I suppose, could do is have information on their own websites or web presences that they control about the fact that the scam is happening, so that when people look this sort of thing up, they're more likely to come across legitimate sites that explain what's happening as opposed to the illegitimate sites.
Oh, that's interesting. That's really interesting. That might be something we can work on with the students if we had a link and information for them so they could just use that information, because it's hard for them to understand. And then if you find one of these, what do you do? So like, let's say I see a designer and I say, oh, look, that's a Tula Pink quilt, and that's clearly, that shouldn't be happening. Like, as a good citizen, is there anything that we can do when we see these sites?
There is. So the FBI, I believe, runs a clearinghouse where they take leads on sites like this. I'm not sure they do much with any individual lead, but I know that they're tracking that and looking for patterns and things like that, and trying to find repeat actors. Unfortunately, I don't have the address right in front of me, but perhaps I can get it to you afterwards, and we can put it in the notes.
Oh my God, they're going to be infiltrated. The FBI. We have to try to interview the FBI now, because it would be so great. And we just like the quilters are on the track. Like, there's a lot of us, right? We could crack this.
Well,
thing.
And I'll tell you, this happens to all sorts of creative content creators. So it's not just. Certainly not just quilters, and it's not just the big guys either. I mean, when I wrote, during the last episode, I think we talked about the book I had written for photographers.
Right.
I remember vividly I had Google alerts set up for the title of that book. And I remember before it was even published, getting email from some websites like this saying that they had a copy of my book, and for some amount I could get a copy for whatever. And it was one of these credit card scams. And I just remember thinking how funny it was, because I was quite literally at the time writing the book.
Right.
And so there was no way they could have had a copy. Yeah. Right, it's just they were pulling ISBN records because that had been created.
Oh my gosh.
And that had the cover art with it. So it looked legit. Even though I was, writing the final chapter and knew that it couldn't be.
That's really interesting. So as a consumer, what is your advice to us to make sure that we don't get into these credit card scams?
So I think when, like you said, if it's too good to be true, it probably is, which is always good advice. Mm-hmm. And I think I would say if it's too good to be true, do some digging, do some research, see if you can find where that, if you see a pattern that you like on a website and the offer is too good to be true, perhaps try saving that image and using Google's image search to see other places on the web where that image appears, and that may lead you to the legitimate site.
The legitimate site, yeah.
Yeah, and I would give that a shot.
Oh, interesting. Super interesting. Okay. Well, next question. We're just random questions today. It's like Random Question Friday. Okay. So we have a bunch of fabric, and it has licenses on it that says non-commercial use on the fabric. We want to know, and I know you've answered this before, are there really restrictions? Can we make them for a, I don't know, like, can you sell them at a church fundraiser? Like, if you make a quilt, or like is that restriction legitimate on that license on that fabric?
So two thoughts, and I think the first one both of them actually we got into in the last episode. But the first is, I think people don't have a full appreciation of what commercial use means, and that's because it doesn't really have a formal definition. So in the photography space, for example, commercial use means you're using an image to sell a product or a service. So if I use a photograph in a newspaper, that is not considered commercial use, even though the newspaper itself is a commercial enterprise, right? And even though I'm selling the newspaper, the fact that the image is in it does not make it commercial use. It's what we call editorial use. In this context, I'm not sure that selling a quilt is itself a commercial use. I think if you're doing it at scale, it might be a commercial use. So that's point one.
So if you make 200 potholders for your church bazaar, and you still don't think that's you still don't see that as a commercial use, because
I think that's getting closer to a commercial use because you're doing it at scale for the purpose of selling them versus making one-offs and then selling them as, or using as gifts or something like that.
And do you think then that, let's say you have a Disney print that everybody always wants to know about Disney, but it doesn't even have to be Disney. It can be like Fisney. You have a Fisney print. You have a Fisney print, and you are making something for your kids' school, and you're going to make a whole bunch of them because the kids are going to buy them for like $2 a thing. I don't know what they are. You see that the scale of making 200 of them is the problem, that then you can't use that fabric. But if you made 1 or 2 of them and sold them, it's not the amount that you're selling for, it's the quantity. Is that what you're seeing the trigger as commercial use?
I think it's kind of a mix of both, actually. Yeah. I know that's a very unsatisfying answer, but I think that's kind of the lawyer answer, right? It depends.
So here's another way to go. Let's say, because I'm trying to understand that license on that fabric. When does it trigger the license? So let's say we have a same bazaar. We're going to have 200 objects, and 10 of them are going to be Fisney ones, and 10 of them are going to be something else. It doesn't matter then? Is it commercial use because it's within a commercial context of 200 of them, but only 10 of them are the Fisney ones?
That feels like less of a commercial use to me.
Because you're not relying on the brand itself to sell it. You're not selling Fisney widgets. You're selling widgets, and some of them are Fisneys and some of them are something else. Is that why?
Right. And then you're talking about the brand. I think that introduces another complication, which is, I was thinking about it from purely a copyright perspective, but from a trademark perspective, if you're using the characters or the brand that is on the fabric as the way to sell it, so you're marketing it as a Fisney product, for example. Yeah. Or in a way,
we're not marketing it as a Fisney product. We're just saying we love Fisney, so here's a thing that the kid's going to like it because they're going to take a pot holder because it's a Fisney one. That's the one they're going to choose to,
right. So I think if it is done in a way that is clear, it is not sponsored or endorsed by Fisney.
Yeah, I think that would be obvious. Yeah.
Yeah, I think that would obviously kick you over. But the second point I was going to make, which maybe I should have started with, is just and I know this, we batted this around last time. I don't know enough, frankly, about real property or personal property law to know whether you can just through the sale you can attach conditions. Like I know you can do it in real property, right? That's what deeds are. So you can have in the deed a bunch of covenants that apply that go with the deed.
But the personal property, we don't know.
But I don't know about personal property. And then you're also in this weird space where the copyright license we're talking about is for the artistic work that is on the physical object, the fabric. So that restricts what you can do with the work, the copyrightable work. But I don't think it affects what you can do with the fabric as a physical object because of the first sale doctrine.
Right. Isn't that weird? But the licenses aren't written that way, right?
Well, right. Licenses are written by people that just don't want you to do certain things.
Right, so that they put non-commercial use. My favorite one, I think I may have told you before, was for personal consumption. Yeah.
I think it was said for personal consumption, which is just odd. But
yeah, well, what does that mean in the court? That was on fabric?
Yeah.
So, because, you don't consume usually unless something goes horribly wrong. You're not consuming fabric typically.
Ricardo has been recording, and Corey, who I'm not sure where Corey went to, but Corey and Ricardo have been recording in, we call it Judy's stash. They've been looking at everything she's ever bought. Well, not everything she's bought, but everything that's in her stash, which is like hundreds and hundreds and hundreds and hundreds and hundreds of fabrics at the licensing on it. And so we get them from the whole gamut, both the time period and different brands. But that's one of the ones they found was consumption for personal consumption only. We've seen it a couple times, not just once. That was weird. I don't know. Anyway,
I think the main concern of any rights owner in this context, and this is kind of an indirectly answering the question, but the main concern of a rights owner is that you're not competing in a sales channel that they're already occupying.
Yeah.
So you're not displacing sales of their own potholders, to use that example.
Yeah.
And that you're not doing it in a way that would look negative. It would create bring their brand into disrepute.
Okay.
I think those are the two primary objectives. And so it's one of those common sense tests.
Got it. Okay.
Do you think that that's going to create that problem? Then don't do it.
Got it. And then if there is a problem, you usually get a cease and desist letter and tell you, stop doing this. That's really what happens next, right?
I would be surprised if a rights owner goes straight to litigation. I think it almost always starts with a
the letter.
Snarky letter, yeah.
A snarky letter. Do they usually, like, I mean, because I'm thinking about the church that's scared of making the FISNY things.
Mm-hmm.
Like, it's a risk assessment. Like FISNY's probably not going to come after the church unless the church is going berserk in some sort of way, right? Like, stay off the grid is kind of the idea.
Yeah, I mean, and we talked about that last time too.
Did.
I mean, there's a difference between putting it on your own website and then having it on, billboards throughout town, kind of
yeah,
thing.
exactly. Don't
exactly
put it on
right.
billboards. All right. So that was my second question. My third question is going to shift gears a little bit. I've been looking at the copyright board. So when you register a work, if something goes wrong, then you can appeal it, and then if it still doesn't get accepted, it goes to this space, and those are publicly available. The copyright board opinions, they're letters, right? But you can sort of see why things get rejected and what isn't rejected. And you used to work at the Copyright Office, and I know that you were not officially part of the board. But this is what I'm finding, which is really interesting. When it seems like logos, it's harder to get copyright protection on logos. They're rejecting a lot of that. They seem to see that there's a lot of they don't want, which I thought was interesting. Jewelry also seems like it's a little bit of a harder hurdle to get over jewelry. There's a lot of jewelry rejections.
Yeah, although I think for different, so I haven't studied the latest review board opinions, but my guess is the argument with jewelry is that there's a strong functional piece, and then with logos, it's originality. It's just not usually enough. Yeah.
Yeah, and then we saw a few with fabric, which I found really interesting because it was like gingham. There were certain things that they were just like, yeah, that's a plaid everybody knows. So I thought that was really interesting. That what they're trying to say is like, we don't want to lock up stuff that's general. But what I also didn't see was a lot of artwork or a lot of, I saw it was very kind of functional. Like there's millions of records and there's not millions of rejections. So we go back to this question of property right on what you're getting and what you should be thinking about. And after the conversation I had with you, I had more conversations with people, and that's kind of why we came back. So we have these, it seems like how much originality do you need? It's not clear to me. I mean, some of the rejections I'm kind of surprised at. Like, I think, whoa, like that seemed like it had enough creativity in my view, right? That's just a judgment call. But like, I always thought of modicum of creativity as really minimal. Mm-hmm. And I'm wondering if it really is minimal. Like, do we have a big, I mean, I always think like school, I'm like, oh, it's just like the alphabet. Like, as long as you push that hurdle, you're fine. I don't know. The copyrightability and infringement, same side of this, different sides of the coin. How can you help us understand where those boundaries are and when we should be concerned?
Well, so I think, it's interesting you mentioned the plaid example. I kind of view it as, you're right, originality is sort of the baseline standard, but then there's these other kind of tensions or pressures on what is and isn't copyrightable. And I kind of think of things like plaid as almost, and this is not a doctrinal argument, so hopefully the other law professors listening won't get too upset by this, but it almost feels like a scenes affair kind of argument in the visual art space, right? Like, this is such a common thing that we can't protect it because it will prevent people from having that in the lexicon, right?
Yeah.
And it's almost like again like a visual application of idea expression dichotomy.
Yeah.
It's a completely imperfect example, but the principles behind those doctrines are that we don't want to lock up things that are so common as to prevent people from engaging in kind of normal speech, right? And that, I think what you're seeing is the visual impression of that. I mean, a good example that's floating that I think they just sued actually to reverse the board decision was American Airlines.
Yeah.
Their rebrand from a few years ago is like a kind of a stylized eagle with the colors red, white, and blue.
Yes.
And the Copyright Office wrote a very clever opinion using a bunch of flight references, but they basically said, this is a trapezoid that's red, white, and blue that kind of looks like an eagle, and that's not enough.
Well,
right?
I mean, that's what was so interesting about it is that they kept going back to with the logos kind of freaked me out a little bit, Chris, because I think, and this is sort of related to what the Copyright Office is doing, is because they kept saying it's a common shape, and they were just putting together common shapes, and so therefore it wasn't protectable. But that's what you do in quilting, right? That's exactly what you do at quilting. You take a bunch of common shapes and you put them together. And we have a totally huge public domain of things, the scenes of fair, idea expression dichotomy, a pool of stuff. But I'm not seeing rejections for copyright for quilting, but it did seem to fall. So that led me to my next question, which was like, do you see the Copyright Office, like, I'm not sure how it functions in the sense of like, are there people that are just focused on the logos or the sound recordings? Is it kind of patent-esque in the sense of how it's getting processed through the Copyright Office, that they have an expertise of like, oh, this logo, like the American Airlines one, is too generic? Is that, do you know what I'm saying? Like, it's not supposed to be like patents, but it started to feel a little bit like patents.
Yeah. So two responses. First, on the shapes comment, I think it's a matter of degree, which is another one of those really not satisfying answers. But I think what you're seeing is you can make that argument about any creativity, right? I mean, a book is just an assortment of letters that have been put into certain order, and music is just there's a universe of rules we follow when we write music, and so any particular piece of music is just arranging those various elements in a certain way. And I think you can say the same thing for logos or quilting designs or any of the visual arts. It's a bunch of common elements, shapes, color, technique that are put together in a particular way. And there is at some point some threshold that is not well defined, but there's some threshold over which there's copyright interest in it.
Right.
So there's that. But to answer your operational question about the Copyright Office, at the initial registrations phase, yes, there are, I think it's 3 divisions. I'm testing my memory. It's been a few years. There's the Literary Works Division, the Visual Arts Division, and the Performing Arts Division. And they handle registrations for each of those specific classes. So the person looking at, say, a logo registration or a quilting design registration would be in the Visual Arts Division, and they would make the initial determination. The examiner who looks at that would make that initial determination. I don't think the board, I don't remember the composition of the board, so I'm not sure. I think that's kind of more senior. They're lawyers that kind of oversee the whole thing. But in the initial instance, at least, it is reviewed by somebody who is, at least has some degree of specialization in that particular area.
All right, so here's the one that got me. So I've been going through every single one of them, sort of trying to understand it. How do you sort of think through it in the categories? There's this star ball. There's a ball, and it's got like it's got a big star in the middle, and then it looks like a ball covered in stars, but it's just black and white. And they were like, I can send you a picture of it. It's hard to, I know I'm not doing, but it's. Here, the board said the work was a combination of black stars that create the impression of white polygons in negative space between the stars, arranged in a circular space, the result of which is insufficient creative design. So that one just kind of got me because I felt like, well, that was kind of creative. Like, it was a ball with stars on it, and to me, it felt like, it kind of shook me in terms of my belief. Like, I believe in, it's like catechism, right? I was taught these things and I didn't understand. It was a logo, so maybe you get less, it's a little bigger hurdle for a logo. But if this was a quilt, this would be a really kick-ass quilt because it's got this kind of interesting thing. But because it's just basic shapes, it didn't get protection. So I didn't know, I just can't quite, and I know you don't have it in front of you and I'm not trying to, but did you see, like, I don't know. Any thoughts about that? Like, and then I don't see it in terms of rejection of artwork or anything else. So that made me, and then I'm going to stop talking because I know I'm going on too long. I'm just rambling. Then it made me think of the modern artists and like, were they registering their works? And, does a Copyright Office recognize that art may be different than, say, logos, that you could have an artwork that's very basic and that they're still registering it? Does that make sense?
Yeah. I mean, it's tricky because we don't have, like, we can look at the review board letters, right? And we can see the universe of things that have been rejected that people have challenged.
Yeah.
That is a subset of rejections, which is a subset of things that are submitted to the Copyright Office.
Right.
So it's really hard to do a whole lot of comparisons between looking at the things that are registered versus the things that aren't. Like, that's really at the heart of this. What we ought to do is just do a bunch of analysis. And it'd be cool to actually see if you could do some like artificial intelligence type thing on this. You have some bot go through and look at all the stuff that gets registered versus all the stuff that gets rejected, and see if it could figure out what the rule is.
Right, but we don't have images on the Copyright Office records. That's the problem, right?
Exactly, that's right. So we'd have to all go to Washington and pull them and look at them. And of course, they don't let you make copies of them. That would be antithetical to the goals of copyright. So it's tricky.
It is.
So without looking at that one in front, and actually I was just trying to find on, as we're talking here,
let me tell you which one it is. It is EUFA Champions League Star Ball device, July 30th, 2018.
All right.
So it's pretty recent. Oh, because it looks like...
It looks like, I would best describe it as looking like a soccer ball, but instead of like the pentagram or hexagon,
like stars.
Whatever it is, it's stars, yeah.
Oh, is that why? Because like they know that this is a standard...
So as soon as he said soccer ball, that kind of led me to, because I was sort of, even without seeing it, I was kind of on your side.
Yeah.
and then when he said
it's context,
it kind of looks like a soccer ball, that changes it a little bit, because that is such a common, like, I'm assuming that anything involving, if your claim substantially involves something that looks like any of the major sports balls, so like
they don't want to lock that
baseballs, up. That's right, exactly. I mean, that's used everywhere as kind of a generic.
But
it's almost like a trademark. There's a genericism to it.
Is it a contextual thing, so that if I make a quilt that looks like this, it has nothing to do with soccer, it will be protectable?
So I think if it were just a bunch of soccer balls on a quilt.
Well, no, this one doesn't look like a soccer. I mean, you can't tell it's a soccer ball. Like if you just made this gargantuan as a quilt, it would be gorgeous. It would be weird and strange, right? But you can't tell. I mean, until he said soccer ball, it doesn't really. I'm just saying, is it a different? Is it contextual? Is it the logo for whatever this company is?
Well,
a Champion Legal Star Ball, like it's a ball, like it's sports. So that looks like a ball. But if it's not in a ball place, would it get protected? Do you know what I mean? Is it contextual? Like the architecture stuff. Like there's a log cabin thing, and the front of a log cabin they rejected as an art institute because they said it was just a regular art. It seems contextual to me. Yeah.
See, I'm looking. So I just pulled it up. I'm looking at it, and I have to say the first thing that came to mind was not soccer ball.
Yeah.
Which is interesting. Now I'm not a sports guy, so
no, me
soccer
either.
Ball is probably one of the last things that would ever come to my mind. But
me too.
I don't. But this does. I mean, but the other thing that comes to mind is that this is just a bunch of stars arranged in a 3D ball like figure.
I know, but that's what quilting is. It's just a bunch of random stars put together in a strange way. That's kind of the essence of quilting, right?
So I guess that's an interesting way to characterize it. So it's in a strange way. I guess kind of
even a boring way.
Is,
right.
Well, how strange is strange, right? That's kind of the matter of degree point I was making earlier. Maybe
how strange
if this
is strange.
that putting it in a ball is not strange enough, but if you did it in a more strange way,
well, I mean, this is right. So this is
original.
This would be strange for quilting because it would be like, well, you'd have to figure out how to do that on fabric, right? That would be really interesting. But it seems like where we're leading is for a group. So the quilters don't know the quilters are all freaked out because they don't know, like, can I do this? Do I have to quote? Do I have to give credit for it? When is it mine? When am I infringing? Like, they're all freaking out, even though none of them are going to get sued. They still want to be good citizens, and they're still freaking out all the time. So it seems like what you're saying, that's why I want to talk to you again, because it seems like our next step in this project is to create a pool of resources that does allow for understanding scenes of fair, idea expression, sort of basic shapes versus copyrightable art. Does that seem like the way to go? Like giving them concrete examples. But these kind of freaked me out because I would not have thought, I didn't think about it contextually, like, oh, this was a live sporting event and that looks like a soccer ball. But I don't know.
The thing that comes to mind, I forget if I mentioned this the last time we talked or not, but the thing that's actually kind of swirling in my head is that project that Peter Yazzie did about
the best practices.
Best practices in communities, right?
Yep,
so
there
was one on filmmaking and stuff.
Yep.
And I feel like
that's what we need.
Because the other thing in my head right now is you're asking all these copyright questions, and part of me is like, well, does it matter?
Doesn't matter. That's right.
At the end of the day, and I take commercial characters out of it for a second, because I think that we can all agree does matter, and there's lines there.
Right.
But something like this, where it's just, we're asking these questions about whether the Copyright Office is going to register something. Do we care? If
right, and they're not registering very often, but they care within their community, right? Because they are like, I made this and I'm showing you. Like, there are prize money and other things. There's some economics to it, but I think it's right of attribution more than anything else. Yeah,
what you're describing to me is resonating with me as more like social norms within the community.
Yeah, I think so too.
And the other work I'm thinking of is Chris Sprigman's book. I forget. I think it's called The Knockoff Economy.
Yeah, we've interviewed Chris. Yeah.
Oh, have you? Yeah. And he talks about. I think in there's a chapter on stand-up comedians.
Yeah.
And how they don't copyright things. Jokes probably are copyrightable. They're not copywriting them, but there's a huge social harm to or sort of a PR hit they take if they steal someone else's material.
Yeah.
And I kind of feel like that's what's going on here. Like, you have these big, powerful quilters that are big in this industry. If you steal their stuff, everyone's going to know it, and everyone's going to point and laugh at you.
You think it's cultural norms?
Yeah, I think it feels like. I mean, obviously, there's this layer of protectability to it, just as there is in the things that Chris was writing about. But I don't think you need it to establish some best practices.
Right.
Or put differently, the best practices are rooted in something other than law, even though there's this
I think so too.
Veneer of law to it.
And I think that, the other question we get is, so we have a couple of cases on quilting, and we see, like, if it was an alphabet quilt, which is really common, and then they copied identically, like, the way the fabric looked and all that stuff. And the court was like, yeah, that's infringement. But then they took another version. I think I may have told you this already. They took another version, and the colors were slightly different, and they added little animals in, and it wasn't exactly. And the court was like, yeah, no infringement. So it seems like even in this case, it's like you're going to get really thin protection. If someone is like nearly doing literal copying of your stuff, yes. But if there's alteration in any way, no. So and then also they did the damages for all the cases with quilters. The damages are awful. Like, they just don't care. Like, they're just like, don't waste our time. Even the How to Make American Quilt, they sued for infringement. The designer on that one, and it's sad because they won the case, but they didn't really get any damages. So
it's interesting though what you just described, like altering it a little bit, changing the color and stuff. That screams to me, without seeing it, but that screams to me derivative work, which of course is one of the exclusive rights.
Right, exactly. But the court didn't see it that way. Isn't that weird?
Yeah, that's interesting.
Totally weird. So I don't know. I feel like I've spent way too much time, your time, my time, thinking about this stuff, and I'm still not. And I can't. Like, we're going to this. The reason why I'm asking to talk with you is because we're going to a convention, and people are going to ask us these questions. And they're not, like, most of the time I just keep saying, like, well, when does it matter? Like, it's your thing of, like, are you going to get sued? Are you being respectful of the artists? It's weird. I don't know. This has been a really weird project on the copyright side.
Well, and it also makes me wonder, and I don't know enough about it to know the answer to this question, but maybe you have some thoughts. Is the value in quilting derived from these patterns? Like, or is there something else going on there?
Sometimes. For the pattern makers it is, but not for the fabric makers, right? It depends on where you sit where you're situated.
In the chain.
In the chain. And also, if you're doing show quilts, it matters because you want to know if you want to make sure that you're not, infringing on, you know what I mean? Like, you don't want to be accused of stealing someone's idea or whatever. So, I don't know. The whole thing is weird. I had one more question for you. It was related to all of this, but I don't know. Crap, I forgot my question.
We've become so confused, we can't think of the next question.
So confused, I can't. It's so true. Well, I think they care most. Oh, yes, I do remember. Permission. So I've gotten from a number of attorneys that work in quilt attorneys. I know, you can't really believe it, Chris.
It's an impressive practice area.
When we were in law school, Ron and I would be, because Ron and I didn't want to practice, and so people were like, what field do you want to go into? And we'd be like, goat law, ballet law, robot law, but because robots aren't people. We are anti-robots. So we were very like, goat law, That was what it was. So quilting law sounds like a little bit like that. I'm a quilt lawyer. But anyway,
it sounds like a hot new LLM program. Actually,
it does. Quilt lawyering
pop up all the time.
Totally,
yeah,
we're gonna do that, and you're gonna teach in our program. We actually are trying to do a certificate program on quilting in the law school. So it's ridiculous. Our life is really ridiculous. So goat law. So one of the things that people are saying to us is just ask permission. So, if you're going to do a sew-along or if you're going to do something, just ask permission of the person. That it's a permission culture. That's what they want, is a permission culture. So the person that you're asking permission from may not even have, they may have done something so simple it's in the public domain, but you're still asking them for permission. How do you feel about that? And would you, as someone who works in LA, do you want the quilters calling to ask for permission? I don't think so. I don't know. I was surprised that was the answer. Just call and ask, or just email and ask for permission. How do you feel about that?
I mean, the challenge when you go to a rights owner and ask for permission for something that is not within the normal kind of realm of things that are licensed is that you get this challenge that nobody wants to answer the question or provide the license because nobody wants to be the first to do it.
Yeah.
If there are no established norms or principles or rules around granting such permission, it's going to be hard to get it.
It's going to be hard to get it, right.
I am generally in favor of asking for permission. However, I'm also quite mindful of the fact that you don't always need to. And I think that's where really educating people, quilters and really anybody who's doing anything with creative content needs to educate themselves about the nature and scope of the limitations and exceptions of copyright law, and as we've been talking about, and make informed decisions.
Yeah.
And I'm not suggesting that everybody needs to go talk to a lawyer every time they want to do a pattern or borrow something or whatever.
Yeah.
But at the same time, I don't think they need to ask for permission each time either. I think they can, there's some lines there, and I think they need to get comfortable with kind of playing in that gray space, which is something that it's easy for me to say because we as lawyers are trained to do that.
Yeah.
That's where we live, right?
Yeah.
But I think, I am also, although I work in an industry that is often characterized as being pro permission culture.
Yeah.
I do think it's generally a best practice to ask for permission, but not when you don't need to, which is again not a very helpful answer.
No,
but I think really kind of getting a handle on when you need it and when you don't is really, really important.
Are you at a computer right now?
Yes.
Can you look up? I want to show you something, and this will be the last part. This is the end of our conversation. No, this is the end. No, I'm just kidding. I'll let you go in just a second. So, never again, Chris. Never. No, I'm just kidding. Put in.
Guess my answers weren't very good.
No, you're brilliant. You're so brilliant. You're like this brilliant thing. Anyway, go to Cherrywood. CHERRY wood. Put in as a search term, and then put prints. And Cherrywood Challenge, they do hand dyeing of fabric, and she is so clever. She's so clever. We interviewed her. This is amazing. So first they did Wicked. So if you put in Cherrywood Wicked, you'll see a whole bunch of green. You see the Wicked Cherrywood Challenge 2014. And what they did is you bought the fabric.
Yep.
And then you made this it's 24 maybe 24 by 24 or 12 by 12 quilt. And you enter it into a contest, and then you either win or not or whatever. And then she makes a book and all this stuff. Well, she's gotten permission from Wicked. She did a Lion King one. She did a Van Gogh one. And then now she's doing prints. And so she gets permission, and they all say yes, and they see it as fan art. And they don't take there's no royalty. She has to put a certain thing onto the copyright page. But these are things that are they're getting displayed at Wicked on Broadway, and they're making tours. And I think this is a super important aspect. This I think is really, really key, because you get the people that are saying yes, they see it as fan. And when it's in that fan-based category, it's different. Do you see that? I'm curious what your thought is about that, and I wanted just to sort of alert you to see what you thought about this whole thing. Aren't they cool? Do you see them, the Prince one? And
yeah, no, they are very cool, and I think so I have two thoughts on this. One is, you're right. It's fan based, and it's obviously serving as a promotional tool in some ways. Generally, I think that rights owners don't care as much about this sort of thing as long as it's not going to be confused for something that they've sponsored or endorsed. And it is not going to, it's what I said earlier, it's not going to harm their overall image. It's also interesting that this Wicked one in particular is interesting because Broadway, I feel like, has an interesting cultural dynamic to it, in that there aren't a ton of places where Broadway brands, for lack of a better word, can be exploited, right? Yeah. Other than on Broadway or, touring shows and things. And so I wonder if they are more welcoming to that sort of thing than other content industries that have much more well-worn, established, longer tail distribution.
Yeah. Well, it's so apparatus. Funny. She said on that one, because we interviewed her, and she said that, first she did Wicked and it just happened accidentally. And then she was like, and then Wicked was like, she's like, I'm thinking of doing another one. What do you think? And they're like, yeah, do it. Just don't do Wicked. And she was like, I just don't do Lion King. And she was like, oh, I'm totally doing Lion King now. And so then she couldn't get permission from Disney because, she was a regular quilter. She's this little business. And then finally, so she just said like something about like Lion, like it wasn't Lion King, but it was like King of the Jungle or whatever. And then finally through the Broadway group, because it was a different group, they said yes. And so then they rebranded with Lion King Challenge. But she said it was so interesting. And then with Prince, they gave her permission. The estate, they were fine with it, and Van Gogh was in the public domain. So, but it was interesting. If what does this tell us? Like, how do we understand fan-based work? And I think if quilters understand that if their work is in that fan-based category, it's different than in other categories. Does that seem right to think about it that way?
Yeah, I think so. And I think it all goes back to the 2 points I made earlier about this, harming reputation stuff. And that flows from being a fan, because if everyone knows you're a fan and you're creating this stuff as a fan, the likelihood of it ever being confused for something that is quote unquote official is minimized. Right. Yeah. So, I think also, and we talked about this a little bit last time, I think as this stuff becomes more commonplace and as people expand the, creative spaces in which they work as a result of advancing technology and things like that, and I think more rights owners are going to realize that it is not the end of the world to have this stuff out there.
No, it's good for them.
And I know another example from Broadway. I mean, there's a big show now called Dear Evan Hansen, which just started its national tour. Yeah. They have bent over backwards to encourage fans to create their own versions of things. Like if you go on YouTube, you will see, I think it's on one of their official channels, they have a bunch of people singing songs from Dear Evan Hansen.
Very interesting.
Often with the actual music behind it, but singing their own versions. And they're encouraging it. So
and we saw that with Hamilton too, all the Hamilton art. But they were taking down, like, this is the divide that you face, right? So they seemed very good at getting things off of YouTube that were the, watching Lin-Manuel Miranda on stage. Like those were coming down fast, but the fan art was staying up, so that they recognized the difference between the two.
Well, so what typically happens, just to give you a little bit of information about how YouTube works under the hood, what probably happened there was that somebody uploaded a bootleg of the show.
Yeah, right.
They went and identified that as theirs and then created that as a reference and said, anything else online that looks like this, take it down. Because what we find in our industry is that there are lots of bootlegs floating around, but often there's only a handful of they all derive from a handful of common sources. So if you can identify those common sources, it becomes a lot easier to police it. And so people are making copies of the same bootleg and re-uploading it, but Google can identify, or YouTube can identify that and block it before it gets uploaded. Whereas the fan stuff is quote unquote original, so it doesn't get blocked.
Okay, so related to that, so I have had this happen to me many times now. Well, and one was really cute. So I'm going to tell you a cute story. So I go to this lady's house who I adore. She's local, and she shows me this quilt she's made. It's a wall quilt, and it's a music quilt. And she says, I'm not using the lyrics and the music in it because I'm afraid that I'd get in trouble. But the quilt itself had a big image, a photograph of the person as part of the quilt. Like that didn't bother her, but the image, she was afraid that she wasn't allowed to reproduce the music. So I get this over and over again of like, can I make a copy? So I think that they fall into fan art and they should just be chill about it. You know what I mean? Like, they're not selling it. They may be showing it at their local, they may be even showing it in a national thing. But if this group is getting, if it's okay, it seems like this is giving us a better sense of fan art is fan art. And there's a space for fan art in our world. Does that seem right?
Yeah. That, and what you just described seems pretty, like the music piece, that seems pretty low risk to me.
Me too.
I think. Yeah.
I was like, it's going to be okay. Like, really. It's particularly since it's like hanging in your living room.
Right.
Like, it's going to be fine. You really can do whatever you want. It's hanging in your living room. That said, I do worry about having that out there. So if you get to like a Dr. Seuss or, a Disney or other people that are creating copyrightable material, is there a risk that the higher, more profile people like a Dr. Seuss that you're going to run into? Does the same rule apply if you've got a copyright holder who may not be as loving with fan art? Like, is there still that worry that you may hit somebody who's upset with you, and then maybe what are they going to do? I mean, I still don't really know what they're going to do. Are they going to tell you to stop showing your quilt for 2 days in a local quilt show? I mean, I don't know. It just seems I'm trying to sort of see, like, what is the possible risk, but I'm not sure.
Yeah, I mean, again, I think a lot of the risk flows from how close you are to commercial channels that particular rights owner already occupies. So if it is just you made a quilt that looks like a Dr. Seuss character, and I'm not representing the Dr. Seuss estate, I don't know anything about their policies, but
right.
If I were looking at that and it were just displayed somewhere and there was no money and you weren't selling it or the pattern or anything, I can't imagine a rights owner wanting to put the time or effort into dealing with that.
Yeah.
If however, it's the kind of thing where everybody says, oh my God, I really like that. Will you sell me the pattern? That starts to look like the kind of thing that they would license. And so now you're kind of treading on their business in a way.
Yes.
And so that, and for me, at least, if I did represent it, that would be the line for me.
Yeah.
But
now, what about like
inspired
by, like that? Like we had this really cute. I really like her, this quilter, and she was like, "Oh, I went to Burning Man, and my picture looked just like this architecture at Burning Man, and I'm really afraid that like I'm gonna if I show it, like I'm gonna get in trouble." I'm like, well, first of all, that would be really antithetical to Burning Man if they like sue you over something like that's just weird. But then secondly, it was like, so I saw it and like it looked nothing like the picture. Like it was like Corey was here. She's like, yeah, no. But like this concept of inspired by, when like you can't even see like how they could possibly be inspired. Does that seem like it's like how close it is to the? Does that make sense? Like the Prince ones, like some of them are just like tears on a purple background, right? So that's not going to be like, do you know what I'm saying? Like they should be thinking about it that way too, right? The more creativity, the further you get from the original source, the better in some way, right?
Well, to put it in copyright parlance, I think it's less of a derivative, right? The further away you get, the more original it is.
Yeah.
And again, it's a matter of degree. The problem with that, of course, is that everybody sees things a little bit differently. And the example I always use is that dress picture that was big on Facebook a year or so ago, where people couldn't decide if it was blue or black or gold or black. I forget the colors, but And in copyright world, the thing that it reminds me of is the Blurred Lines case, where Robin Thicke and Pharrell Williams were sued for stealing the beat from the Marvin Gaye song "Gotta Give It Up." Yeah. I first heard that Robin Thicke song and thought for sure they had cleared the sample. I thought it sounded exactly like "Gotta Give It Up."
Right. No.
My friend, who I was with at the time, said, "What are you talking about? It doesn't sound like that at all."
Oh,
and that was exactly the issue. Was that you can't, it's just different people hear, see, and perceive things differently. And so answering that question, I think, is really
I think that's
challenging.
Great. The other one we get, and I totally promise I'll stop, is subconscious copying. Like I can, all these different designers are like, well, I just don't look at anybody else's stuff. And it's like, well, that's not true, right? Like you're out in the world and you're at a quilt show and like you can't help but be in the world and see stuff.
Right.
So I don't know how you deal with that part, but it's like you can't. If you're part of an industry, you're gonna hear the music. You're gonna hear, you know what I mean? Like,
well, that's what has always made me very nervous about the standard for copyright infringement, right? Which is substantial similarity and access. And if you can show that something's, if you had access, or if you can show that a plaintiff. If the plaintiff can show that the defendant had access to a copyrightable work, that's these days with the internet, that's a pretty low bar.
It's a very low bar.
And so, like, what that means, I think there's actually a case floating around now. I forget which circuit it's in, but it's dealing with that question of what access means if something's just on the internet.
Does that feel sufficient? Like, is that for the studios like really difficult? Because it seems like, oh my God, it seems like that would be very difficult of people claiming like, oh, we already had that story and blah blah blah, and I had it on like the most important, like it had 50,000 hits from blah blah blah. How could you not know it, right? Like it seems
and it's especially challenging in our business because we joke about this, but it's kind of true that there isn't really an original idea in Hollywood. Like there's a strong likelihood that whatever story idea you could come up with, somebody somewhere in town has already thought about it.
Yeah.
But that sort of thing happens all the time, and it does make things very very challenging. And we've solved that to some extent through structural things. Like we only tend to look at submissions that are brought to us from known agents and things like that. So there's kind of a trust involved that kind of circumvents the copyright issues.
And are you putting a warranty on those ideas? Are you pushing it off to them to say, like, are you warranting this is your own idea? And if you get sued, it goes back to you guys? Like, it seems like...
It is standard practice so that's a little out of my area, but my understanding is it is standard practice in the business for the author, like a screenwriter, for instance, to certify to warrant that it is original work.
That's really interesting. Well, with the Cherrywood thing, she put it back onto the creators to say, like, any copy, like, don't use copyrightable material, and if you do, it's just on you. Like, it was really interesting that she was clever enough to recognize that she's not, even though she's publishing books and doing stuff with the material, that she's putting back that disclaimer back on. I mean, doing the warranty back. So that's really interesting. Wow, Chris, you're the guy. You're the guy. Who's the guy? Chris is the guy. Like, Chris is the guy. Like, we talk to a lot of people. It's funny. Like, we have more than one copyright person come on, but I feel like I just need to talk to Chris about these things. And like, I don't know. You strike a balance of reasonableness and trustworthiness that I really like. So,
well, thank you.
Right?
That's how I try to attack all these things, and that's always when I teach. That's something I try to impart on students, both law students and otherwise. It's just, a lot of this comes down to just good judgment and reasonableness.
Yeah.
And also the adage, just because you can doesn't mean you should. And I tell people that all the time. Just because someone's stealing your stuff doesn't mean you need to sue them. And just because you don't think you'll get caught means that it's okay to steal it.
Yeah.
So it's, it plays both sides. If everybody just follows those rules, we'll generally, we'll all get along.
So you've been listening to Just Wanna Quilt, a research podcast coming out of Tulane University Law School. And I'm Elizabeth Townsend Gard. If you like this podcast, keep listening. Also, we have a Facebook group. Come join us. We talk about a lot of things. We also have an Instagram account. And of course, most importantly, I really hope you get a chance to quilt today.